All right, let me get us started. Welcome, everyone. My name is Carol Levine, and I have the honor of chairing Courts Matter Illinois. This is the first of 6 webinars in our series, Courts Matter to the 2020 election. This webinar is our webinar on Courts Matter to LGBTQ issues. First, let me give you a couple of housekeeping things. All mics of participants have been turned off. Cameras are off so you can concentrate on our speakers. We ask that if you have any questions for our speakers during this webinar, that you put them in the Q&A box. Down at the bottom of your screen, there is a box marked Q&A. Please type your questions into that box and we will get to them towards the end of this webinar. If you have comments on what's being said, please put your comments in the chat box. That's the box next to the Q&A box. And we will also be checking that box. This webinar is being recorded so that we will be able to go back, and if you want to hear more about it, we will have the recording available to you, and it will be posted on the Courts Matter Illinois Facebook page. I want to start by thanking the sponsors of our series, all 6 of these webinars. They are Chicago Women Take Action, National Council of Jewish Women Chicago North Shore Section, National Council of Jewish Women State Policy Committee, Planned Parenthood of Illinois, the American Constitution Society of Illinois, National Employment Lawyers Association Illinois, and the Citizen Advocacy Center. And we have 3 co-sponsors of this specific webinar: Equality Illinois, Lambda Legal, and the Lesbian and Gay Bar Association of Chicago. We are very grateful to all of our sponsors. I also want to give you a little bit of background on just who Courts Matter Illinois is. Courts Matter Illinois is a coalition of diverse organizations and individuals working to ensure a federal judiciary that's comprised of judges committed to upholding core constitutional values. And if you want to know what core constitutional values are, they include such things as voting and civil rights, workers' rights, freedom of speech, and the separation of church and state, and the right to privacy, among other things. Here is some of what we do. We educate the public and our elected officials about the importance of federal judges who sit on the U.S. District Circuit and Supreme Courts. We provide information to the community about the judicial nominations process and judicial nominees who will impact our constitutional and other fundamental rights. We support a judicial nomination process that is fair and identifies well-qualified, diverse, and unbiased, nonpartisan nominees. We mobilize our communities to speak out and take action on federal judicial vacancies. Courts Matter Illinois monitors and takes action to ensure fair consideration of federal judicial nominations because of the immense power held by the individuals who hold lifetime appointments to the federal courts. That's what we do, and that's who Courts Matter Illinois is. Now, before we launch into our discussion of Courts Matter to LGBTQ rights, we thought it might be helpful if you all understood a little bit more about the federal courts process. So we put together a 5-minute process, PowerPoint on Federal Courts 101, and I promise you it will take 5 minutes. So here you go, Federal Courts 101. Can we have the next slide? Okay, the federal courts actually are made up of 3 parts. You all know about the Supreme Court with its 9 justices. Then there are the U.S. appellate courts. These are the courts that you hear more about. This is where appeals are heard. There are 12 circuits and 179 judges who sit on these courts. And then there are the circuit courts with 686 district judgeships on those courts. So there actually are 3 layers of federal courts. Next slide. What you need to understand about the courts are that there are circuits all over the country, and if you look at that map, you'll see that Illinois sits in the 7th Circuit along with Wisconsin and Indiana. The important piece on this slide is over on the left-hand side where it says the federal courts heard in 2018 407,000 cases. Now, that's the federal courts. The Supreme Court heard less than 100. Next slide. Okay, so this is how the process for getting on to becoming a judge used to work. When a vacancy was created, the President of the United States would consult with the senators in the home state where that nomination, where that vacancy was, about candidates. The candidates recommended by those senators would be vetted by the White House, and then a nominee would be announced, and the home state senators would agree and return what was called a blue slip, simply a blue piece of paper. The nomination would go to the Senate Judiciary Committee. Yay or nay vote would send that committee to the Senate, who would vote to confirm that nominee. That's how it used to work, pretty simple. Next slide. Next slide. Okay, this is how it works today. When a vacancy is created, the president today consults with the Heritage Foundation, the Federalist Society, and other right-wing organizations, rarely consulting with the home state senator. The White House vets those nominees, and they are formally announced by the White House. No blue slips are being used anymore. The nomination goes to the Senate Judiciary Committee, where hearings on these nominees are very rushed. Sometimes many candidates are heard at one time. Questions are limited. Times are limited. There's very little time given to the process. And a yes sends the nomination to the floor of the Senate for a confirmation vote. In other words, the process is truncated and very, very little time goes into the process at all. Next slide. On the Senate floor, most nominations were scheduled by unanimous consent, meaning that all 100 senators agreed to limit debate and allow a floor vote. And what is happening now is the confirmation is happening by filing cloture. As a matter of fact, there will probably be a vote because cloture was filed on a nominee yesterday, and there will be a vote on a nominee today or tomorrow. It only takes 51 votes to confirm someone to a lifetime appointment on the federal judiciary. So in other words, you get a lifetime seat if you get 51 votes. And debate on the floor is now limited, I believe, to under 3 hours, which means there's no time on the floor from the time the nominee comes to the floor and cloture is voted to really vet that nominee by the full Senate. Next slide. Okay, The American Bar Association used to be called upon to rate nominees before they were even brought to the floor. And this is a slide that shows how many nominees in the last 2 years were rated not qualified by the American Bar Association. More in the last 2 years than ever before. Trump nominees in the last few years not only were not rated qualified, they were not diverse. They were often said they would not state that Brown versus Board of Education, which indicated that separate but equal education was not separate but equal, and did away with that law, that they would not state that that was righteously decided. And that was a unanimous decision by the Supreme Court. They have been, what can I say? They have not been well qualified. Let's just put it that way. And this slide just gives you a sense of what that was like. Next slide. So if you're asking what you can do, 1 is pay attention. 2 is talk about this. People don't talk about the courts. 3 is call your senators and urge them to reject candidates who are not qualified, who seem to be extreme, and who just don't meet basic qualifications for people receiving lifetime appointments. And 3 is talk to others, tell them about the courts. And of course, the last thing is to vote and to ask other people, ask candidates where they stand on the courts. That's really important. So that's Courts 101. And now I'm going to turn this over to a member of our steering committee. Megan O'Malley is a founding member of Courts Matter Illinois. She's also a civil rights attorney and a founding partner in the law firm of O'Malley and Madden, where she concentrates her practice in employment discrimination and whistleblower matters. She has represented numerous LGBTQ individuals who have been the victims of discrimination in their workplace practice, and she's going to moderate our conversation this afternoon. Megan, thank you.
Thank you, Carol. And if I can ask our panelists to turn your videos on. Thank you. And it's very exciting that we get to have this webinar both in Pride Month, but also a week following a very surprising, but very pleasantly surprising victory in the Supreme Court. So we have 3 fabulous speakers today who are very involved and have been very involved in the protection of LGBTQ rights and protections, including in the courts. And I would like to introduce you to all 3. We have Cecilia Horan, who is a judge in the Circuit Court of Cook County in the Chancery Division, where she has sat on the bench since January of 2017. Judge Horan is also a member of the Board of Directors of the Alliance of Illinois Judges, which is an association of judges, LGBTQ judges in state and federal judiciary here in Illinois. Judge Horan is also the immediate past president of the Lesbian and Gay Bar Association of Chicago, where she currently still sits on the board, and that is an organization for lawyers, law students, and legal professionals in Chicago. And then we also have Camilla Taylor here with us today. She is the director of Constitutional Litigation for Lambda Legal. And as many of you know, Lambda Legal is one of the oldest and largest national legal organizations committed to achieving full recognition and civil rights for lesbians, gay men, bisexuals, transgender people, and people living with HIV. Camilla also spearheads Lambda Legal's litigation challenging the Trump-Pence administration's assault on LGBT rights, which is timely again because earlier this month, the Trump administration rolled back protections that were put into place by the Obama administration for transgender individuals in healthcare. And so thank you for your good work and expect you to be on that as well. And then Mike Ziri is the Director of Public Policy at Equality Illinois, which is the state's civil rights organization for lesbian, gay, bisexual, transgender, and queer people. Mike spearheads the organization's legislative agenda in Springfield, and he develops relationships and maintains relationships with political leaders both in Springfield as well as Washington, D.C. As part of the organization's efforts to develop and advance policy initiatives to address the needs of the LGBTQ community. So we thank you all very much for your participation in the webinar today. And I want to start with you, Judge Horan, and just sort of expanding upon what Carol introduced, which is why care about this topic, and not just LGBTQ rights, which I presume everybody on the call or the webinar here today, in fact, cares about, but also how the courts affect those rights. So why care about the courts? Yeah, so if you could take over for me now.
Yeah, sure. Thanks, Megan.
Of course.
First, as you know, this isn't just an LGBTQ issue. How the courts interact with all minorities is important. The topic is important because, as I'll discuss later in this presentation, more than ever, the average Joe is coming into contact with the courts, and more than ever, the average Joe might not be white and straight. Studies show that people, especially minorities, perceive the courts to be unfair, particularly to underrepresented groups. The courts, in my view, are facing a legitimacy crisis, which threatens to break down respect for the rule of law. Studies also show that a diverse bench leads to both better outcomes and better experiences for diverse litigants. In my view, it's in the interest of both equality and justice that judges reflect the parties and the populations that they serve.
So I mentioned the recent victory in the Bostock case, which was actually a trilogy of cases from last week's Supreme Court. And I know that Camilla is going to talk to us a little bit more about the details of that case. But one of the issues was, how do we interpret the word sex, prohibiting discrimination on the basis of sex? And one of the things that the court discussed in Bostock, as well as in prior cases like Obergefell, which was the gay marriage case, was how the courts are there to interpret the laws by the legislature, in addition to deciding constitutional rights, but also to interpret what does it mean? What does the word sex mean? What does sexual harassment mean? And so if you could maybe explain, Judge Horan, to our audience how it is that judges make law, because I think a lot of times we hear judges aren't supposed to make law. That would make them an activist judge. But judges, in fact, make law every single day without being activists. And so maybe if you could help our audience understand how that works and how they're just doing their jobs, that would be great.
Sure. The legislature will draft a statute, and the statute will be enacted. And then it isn't until the case comes before the court sometimes that the court has to interpret what the legislature intended. And that was, in Bostock, that they were talking about the Civil Rights Act of 1969 and what the word sex meant at that time, and how, did the word sex mean then? Did they intend to interpret that word to cover sexual orientation? Surely they didn't, but does the judges can take measure of society and what's going on in society and expand the interpretation to suit our needs today.
Thank you. And you mentioned earlier that that applies not just in the arena of LGBT.
I think we got cut off.
Can you hear me?
No.
Megan?
John?
Oh, there you go.
Oh, I'm sorry. Can you hear me?
Yes.
Yeah.
Okay, I apologize. Can you see me?
Yes.
Yes.
Okay, a little technical difficulty over here. I apologize for that. So what I was saying is that applies not just in interpreting laws as protective of LGBTQ community, but also anything, right? It would be, you know, environmental protections, voting protections, what you know, what does the Clean Air Act require? What does, you know, that kind of thing. So that's why it's important, especially in the area of civil rights, that we have judges who will interpret the law fairly and in a way that context matters. So I mentioned that Camilla was going to tell us a little bit more about the Bostock case. And can you guys still hear me?
Yes.
Okay, my screen is frozen, so I apologize. And so Camilla, can you explain what Judge Horan had started to explain, what the issue is, and what the issue was in Bostock, and how it was that the court had to come in and interpret the law in a way that could have either curtailed the rights, but in fact, in this case, expanded the rights of the LGBT community?
Sure, Megan. And first, thanks so much to Courts Matter Illinois for including me today in this discussion. So the decision that came down last week really was blockbuster. And that is because a majority of states in this country still lack any explicit protection for workers, employees, based on sexual orientation and gender identity. And here in Illinois, we're fortunate to have a state law that prohibits discrimination on those bases, thanks in large part, to groups like Equality Illinois and to the work of people like Mike Ziri, who've been very successful in pushing legislation forward. But in most states, there is no equivalent state law, and there is no federal law that explicitly prohibits discrimination based on sexual orientation and gender identity. So the question before the court in this case, in Bostock versus Clayton County, and there were 3 cases, 2 involving gay people who had experienced employment discrimination based on their sexual orientation, and 1 involving a transgender employee who had been fired because she's transgender. And the question was, does that type of discrimination constitute a form of discrimination based on sex? And the court concluded that it does. And in doing so, the court protected all employees covered by Title VII across the country, no matter where they are, which is many thousands of people suddenly experiencing job security from this type of discrimination that they didn't have the week before last. And the court's reasoning was this, and it is essentially a really conservative argument that you look to the text of a statute. And if the text of the statute is clear, then you don't need to get into the minds of the heads of the people who drafted it in 1964. And the text of the statute says because of sex. And if a gay person is fired because, say, their name is John and they married James, but a straight person named Jane who marries James does not experience the same discrimination, then that is a form of sex discrimination, as well as being discrimination that targets John because of his sexual orientation. Similarly, if a transgender employee comes to work and says, I would like you to change my employment records to reflect my gender identity and to refer to me by my name because I am transitioning and I would like to live as the authentic woman that I am, and gets fired on that basis, then that is a form of sex discrimination also. So this was a blockbuster landmark opinion that made a huge difference in the lives of LGBT people. But it is one of many Supreme Court decisions that have transformed the lives of LGBT people in huge ways. And that is because we haven't made significant progress at the federal level with respect to legislation. With respect to protecting LGBT people from discrimination, the Obama administration passed a number of regulations that were crucial in protecting people on an agency level, but many of those are in the process of being rolled back by the Trump administration at the moment.
And Camilla, if I could, when I was dealing with my technical difficulties, I wasn't sure if I heard you mention that this was not a unanimous decision, right?
No.
Yes. So this is an important aspect of what we were talking about today, is why the courts matter and why the nominees and the individuals who are seated on lifetime appointments to the federal bench matter, because the courts were very split on what the definition of sex was, and there was actually dissenting opinions. So do you want to tell us a little bit about that?
Yes, there was a very significant and lengthy dissent in the Bostock decision. And in fact, all of the landmark decisions that protect LGBT people that have come out of the Supreme Court in the last 10, 15 years have been split decisions, and many of them by only one vote. And so that is how crucial it is that we appoint people to the courts, particularly the appeals courts, but all levels, that have integrity and that are willing to judge a case based on the law itself and not coming to it with a particular anti-LGBT ideology. And unfortunately, under the Trump administration, many judicial nominees appear to be selected precisely because they have an anti-LGBT ideology. And Justice Kavanaugh is turning out to be one of those nominees based on his ruling in Bostock and in other cases.
And in Bostock, the dissent, in fact, had stated that there's no way that the drafters of the legislation back in 1964 could have envisioned that sexual orientation or transgender would be included in the definition of sex. But interestingly, it was Judge Gorsuch who wrote the majority opinion who stated that, but the limits of the drafters' imagination supply no reason to ignore the law's demands. So that was a surprising twist in who wrote the opinion and how that came out. But as we've seen in other cases, that in the Obergefell case, primarily, that the judges have recognized that the law does in fact have to evolve as human understanding evolves as well. And so I think that that's a very good example of how different judges will see something and interpret it a different way. What are some of the other significant cases from the Supreme Court that you've seen that have developed over time to give protections or sometimes jeopardize those in the Supreme Court? And you mentioned a lot of them have been 5-4. Can you tell us about that?
Sure. And I don't want to miss an opportunity to celebrate the decision preserving for the time being from last week also. There, of course, are many LGBT people among the Dreamers who got an unexpected boost by the Supreme Court striking down the Trump administration's effort to erode and remove DACA's protection for Dreamers. And I think that case also has particular relevance to the LGBT community as well, because the Supreme Court's ruling in the DACA case was that the Trump administration had failed to consider all the adverse consequences on young people who were brought here when they were children and who don't have a path to citizenship and yet know no other country as their home. That the Supreme Court said that the Trump administration's failure to consider the adverse consequences adequately was one of the reasons why the Trump administration's actions should be struck down under the Administrative Procedure Act. Well, that same argument is what we are making on behalf of LGBT people against numerous assaults that the Trump administration has rolled out pretty much, one every few months, rolling back Obama administration protections for LGBT people from discrimination. And we are arguing that the Trump administration's regulations that roll back these protections also lack adequate concern for all the people who are going to be hurt. So the ruling on DACA is actually a very meaningful ruling for people who are experiencing targeting by an administration that's singling out minorities, and that could be of great use to us in our litigation going forward. But to go back to the landmark precedents that have transformed the lives of LGBT people over the last generation, of course, we're familiar with Obergefell from 2015, which swept away the last state laws that prohibited gay people from marrying. That protected same-sex couples and allowed them the freedom to marry on the same terms as different-sex couples. Then before that, in 2003, there was a decision of the US Supreme Court that allowed the marriage litigation to start in federal court. And this was Lawrence versus Texas. And in Lawrence, the Supreme Court said that laws that criminalize intimacy between people of the same sex are unconstitutional. And the government doesn't have any role interfering with people's private lives like that. And that was crucial because it meant not only could gay people no longer be prosecuted simply for being in relationships with someone of the same sex, but at that time, simply the existence of sodomy laws in some states meant that anyone who came out as lesbian, bisexual, or gay was a presumed criminal and could be fired from a job as a public school teacher or a police officer or an attorney working for the state. Anyone could be deprived of the ability to foster a child or to adopt or lose a child in a custody dispute simply because of an assumption that if you're lesbian, bisexual, or gay, you are therefore presumptively criminal in some states, even if not in our state.
Well, and wasn't that didn't the Supreme Court in the Bowers v. Hardwick case actually put its own imprimatur on criminalizing sexual activity between gay persons?
Absolutely right, it did. So before Lawrence versus Texas, there was a 1986 decision that was one of the worst decisions in the LGBT civil rights movement. And in that decision, a challenge to a sodomy law brought by a gay man in Georgia, the Supreme Court ruled that it would be facetious to suggest that there was some sort of fundamental right implicated by a law that criminalizes people simply because they're gay, lesbian, or bisexual. And that Supreme Court decision made it very, very difficult for us to argue that gay people should enjoy any rights at all in the courts, because if they're presumed criminals based on who they are, how do you argue for the right to marry? It was a time of great hostility in the federal courts, very challenging to litigate on behalf of gay people, let alone lesbian or bisexual or transgender people. And at that time, we turned to state courts. And we're talking a lot about federal courts here and how federal United States Supreme Court decisions have transformed the lives of LGBT people and caused this blossoming of people coming out and taking pride in who they are, which is very, very difficult to roll back. But there was a time of hostility in the federal courts where we went to state courts. And just as Judge Horan explained, state courts take on huge importance for all people, and particularly minorities who find themselves in state criminal justice proceedings and so on. And we went to state courts first when we fought for the right to marry. We wanted to stack up some good precedents at a state court level before going to the federal courts so that we could argue to the federal courts that a growing consensus was there, that state constitutions and federal constitutions too, which are based on the same principles, should protect all of us and ensure that we all have the freedom to marry on the same terms. So we have been before at it, in a place where federal courts were showing increasing hostility. State courts are there. Their constitutions can be more protective than the federal.
And can you explain how the state courts actually were on the forefront of this and teed up the Windsor decision, which predated Obergefell and laid the groundwork for gay marriage in the federal courts?
Sure. So the first decisions holding that same-sex couples are guaranteed a constitutional right to marry were state court decisions, including in Massachusetts in 2004. And Massachusetts stood alone in allowing same-sex couples to marry for a while. The next states to move were Connecticut and then California briefly, although it was rolled back by referendum in Proposition 8, and then Iowa. And then there was a slew of legislative victories, including in New England, that allowed for same-sex couples to get marriage licenses and to marry under state law. And it was because of all of this movement on the state level that the federal so-called Defense of Marriage Act got called into question. This was a federal law that passed in 1996 before any same-sex couples could marry anywhere in the country. And the federal government said that it was not going to recognize any marriages of same-sex couples for purposes of any of the over 1,000 federal rights, benefits, and responsibilities that flow from a valid state law marriage. And the Supreme Court in 2013 struck down that federal law as unconstitutional. And that was in deference, really, to the state court decisions and the state legislation that was allowing same-sex couples to marry at the state level at that time.
And then it was just 2 years after that the court in Windsor striking down the Defense of Marriage Act and recognizing that if you were married in Massachusetts but moved to, Arkansas, they had to recognize your marriage, that the Obergefell decision was decided. And in that decision, Judge Kennedy sort of acknowledged this progress that it became born from the grassroots level to the state courts, and stated that in Lawrence, Lawrence confirmed a dimension of freedom that allows individuals to engage in intimate association without criminal liability, but it does not follow that freedom stops there. Outlaw to outcast may be a step forward, but it does not achieve the full promise of liberty. And he went on to say that the nature of injustice is that we may not always see it in our own times. And so I think that when we don't have the progress that we want in federal courts, we have to look to things like the state courts and the legislation. And that's why it's important to make sure that our courts are definitely well guarded on the integrity, judicial integrity, and the well-qualified nominees, etc. And so, but that is a good example that Camilla was explaining, that, you know, things didn't happen overnight. And when you go and use those state courts to advance the issue and show the federal courts that you can't discriminate against somebody living in Arkansas and give them lesser rights than somebody living in Massachusetts, that's how progress is made. Are there ways, Camilla, that you have seen the LGBT community marginalized in, you know, other areas? You know, obviously we talked about employment with the Bostock case, and we talked about immigration with the DACA case, and marriage, and all the there's issues that have come up with Obergefell. And you know, one of the things we talked about before in our pre-call was the police misconduct issues and how they affect marriage, I'm sorry, not marriage, the LGBT community, and those seem to be timely issues as well. Can you talk a little bit about that?
Sure, absolutely. And Megan, I love that quote you singled out from Justice Kennedy, acknowledging the nature of injustice is that we may not always see it in our own times.
Yeah.
And I think that's a perfect jumping off point to recognize that these victories that have so changed the lives of LGBT people derive from precedents that were the product of civil rights giants in the generations before us, who were fighting for racial equality and who were fighting for sex equality. And those precedents paved the way for us to be able to have the victories that we have, because the Supreme Court expressly cited cases like Loving versus Virginia, which vindicated an interracial couple's freedom to marry, and expressly cited Virginia Military Institute, which was the case that Justice Ginsburg had helped to win when she was still in practice before she became a justice, which struck down laws restricting the ability of women to attend certain public institutions. So civil rights giants before us won the precedents that paved the way for us. And if the Supreme Court next week were to strike down, or as early as this week perhaps, laws that were to allow laws restricting abortion to stand, then that would erode a precedent. Those abortion rights and contraceptive precedents are also cases that were cited and relied upon in cases like Lawrence and Obergefell. And so if we erode the doctrinal foundations by allowing abortion rights jurisprudence to erode, to be attacked, then that hurts the LGBT civil rights movement as well. So there's an intersectionality here that is based on how the law works, and with precedents serving as building blocks for each new vindication of a new civil rights battle. And you cannot abandon the battles that came before you, or else you will lose the one that you're in. With respect to police misconduct and brutality, the LGBT community, just like communities of color, have experienced misconduct and brutality to a disproportionate degree. And of course, you know, many people of color are also LGBT and have multiple reasons for being targeted by police. But we all have a huge stake in ensuring that the criminal justice system and that the structures that exist are not structures of white supremacy. And to the extent that we can combat that, we all know that there are many flaws. And Judge Horan was pointing out that the courts are at a point where they are losing their legitimacy. It will serve all of us if we confront these things, name them, and work to make them better. And just to give you a few examples of how police have targeted LGBT people in the past and what we have done to try to confront that. It used to be that bars and restaurants where LGBT people would hang out, including in Stonewall itself in 1969, from which pride is derived, that excuse my computer there, that police would target those for oppression and would just do a sting, a raid, and arrest everyone there because they were gender nonconforming. And it was at Stonewall that people first rose up and said no, led by transgender women of color. We have fought those bar raids and stings even in the last 5 years. One happened in Atlanta, and we challenged it and won a settlement. But in addition, there's a very famous case, the case of Brandon Teena of Boys Don't Cry fame, where we represented the estate of Brandon Teena. He was a transgender young man who was raped, assaulted, and then when he went to law enforcement to report that rape, the sheriff then went to the perpetrators, notified them of the report, failed to protect him, even when he asked for protection because he feared for his life, and then they killed him. So we were able to secure some monetary relief for the family, but of course there's nothing you can do to bring back a young person whose life was lost as a result of police misconduct or failure to act on the part of a police department. So there are all sorts of different ways that we have to work to make sure that courts operate in the way that they are supposed to, with integrity and with fairness, and that they do not end up recommitting the discrimination that often results in people being before the court in the first place.
And that intersectionality piece is so important because we see discrimination against several minority groups, including the LGBTQ community, in not just employment or marriage, but also in housing. And I see one of our participants is commenting that healthcare, education, those are all 100% true. And we do have some cases that are teed up. One of them is before the U.S. Supreme Court right now, Fulton versus City of Philadelphia, which talks about the rights of the LGBT community to foster and adopt kids and the intersection of religious freedom. And that's an area that intersects very much with healthcare, which is another case that is coming down to before the court as well in terms of the Trump administration's rollback of the protections under the ACA for women's healthcare, reproductive and contraceptive rights, and that's going to have a direct impact on how the court decides later on the rollback of the protections on transgender people's ability to get healthcare under the ACA as well. Title IX protects the rights of students in education, and including, there's the 11th Circuit case, it's not before the Supreme Court yet, but the Adams versus School Board of St. Johns County that talks about what the bathroom issue, and again, it's sort of surprisingly, the 11th Circuit isn't known to be so liberal, but they decided, or the lower court, sorry, not the circuit decision hasn't been decided, but the lower court decided that the student did have the right to use the bathroom of choice. And so those things, we can't forget about the intersectionality. We're talking about how the courts in prior cases, for example, in the Griswold versus Connecticut case and Eisenstadt case, Griswold is the one that said the state can't pass laws barring married couples from using contraception, and because of the right to privacy. And then Eisenstadt extended that to the unmarried couple. And that is, even though Bowers versus Hardwick followed after that, it was later on in Lawrence versus Texas that the court said extended those rights to privacy of sexual activity to the gay and lesbian community as well. And so those are powerful ways and examples of how being intersectional about protecting the rights of everybody can help, rising tide lifts all boats, so the rising tide lifts all rights. And so you mentioned about the police misconduct issues. And Mike, I know that, and looking to places other than the federal courts when you're not advancing in the federal courts as much or as quickly as you'd like to. And Mike, I know that you do a lot of work on the legislative level, and you have looked to advance rights there. And can you tell our audience a little bit about both the work that you have done there, but also how the laws then become subject, it's not the end game once the law is passed, why it's important to have the courts there and interpreting the laws or upholding them, and how impact litigation sometimes looks to strike them down. And can you also talk a little bit about the Illinois Supreme Court case from last week and why that matters to LGBT rights as well?
Sure. And thanks so much, Courts Matter, for inviting me today to be on here, and so honored to be with Judge Horan and Camilla on this panel. But yeah, absolutely. So a lot of the work I do is in the legislative space down in Springfield, the state capital. And like you said, we pass great affirming laws. Illinois is the anchor of equality in the Midwest, but like any state that passes these protections, someone could challenge them. And we've seen that actually across the country. Not in Illinois, but we've seen that across the country with conversion therapy bans. States will pass them, and in some places where the legislature of the state won't pass them, a municipality will. And so we've seen some of those conversion therapy bans challenged in the courts. Particular example I remember was New Jersey's conversion therapy ban. And it made its way all the way up to the Supreme Court. The Supreme Court did not hear the case. They rejected it, which meant the lower court's ruling stood in support of the conversion therapy ban. But you just see how important those courts are, state courts and federal courts. I'm so glad Camilla mentioned state courts, because I feel like state courts in the popular imagination sometimes get overlooked, and yet they are so very important. And in
Well,
state,
the nice thing about state courts is we have the ability to elect the judges or reject the judges.
yeah,
Right?
in Illinois, that's true.
In Illinois, yes.
In Illinois, and we look at our ballots, and there's 30 names at the end of it, and I know it's tough to always research every name, but it's really critical, because the decision a lower court makes can work its way up and become precedent, as Camilla said. So you want to make folks who affirm LGBTQ rights, who understand and adhere to equal protection, equal treatment, the civil rights. And it's just so important.
For our audience, I just want to mention that when we do have elections and judges come out, you can easily find a lot of the bar associations, including the Lesbian and Gay Bar Association, will evaluate each candidate for state office and will let us know if there are things to be concerned about in his or her record, and or his or her opinions if they've already been on the bench. And so that's one of the areas that's something that falls in the what can you do category, which is to educate yourself about these judges. It's really not that hard to find with the internet these days. You can essentially just Google judicial evaluation.
Yeah. To that point, and I know not all of our participants are in Cook County, Illinois, but for Cook County, there's a great website called voteforjudges.org, which brings together all of those different bar association ratings. So you've got the Lesbian and Gay Bar Association, you've got the Cook County Bar Association, the State Bar, the Hellenic Bar Association, all these different associations, and it aggregates them on one website and goes through all of the folks there. So you can look and see, well, how are they rated by the different bar associations? And it's just really, really important and impactful to do that. And, they update it every election. So, the information was on there for the primary. It will be on there for the general. So they just do great work bringing that together. There is another way I wanted to mention how courts are really important for LGBTQ rights and how folks are impacted. And that's, these decisions like Obergefell, like Bostock, they can be catalysts for great change in the movement, but also a reflection of the work that has come before. And just because of the court calendar, they often come down in June, which is Pride Month. But the reason it's important to have these affirming national decisions is because before Obergefell and before Bostock, your civil rights in employment and your civil rights in marriage equality were based on your zip code, essentially. So Illinois passed marriage equality through the legislative process in 2013. We are the last state to pass marriage equality legislatively. But the challenge was you could be married in Illinois, but your marriage rights might not be respected under the law of another state. So really it was a patchwork quilt of your protections, and the same thing for employment. One of the questions I was asked early on about these cases, the Bostock case and the other cases, is why does this matter to Illinois? Illinois has the Human Rights Act. LGBT people in Illinois are protected under law. Well, first of all, we care about queer people everywhere. Everyone should have the same legal protections. But if we're talking about Illinois, it's great that Illinois has these protections, but what if you were an LGBTQ Illinoisan who lives here but works in Kentucky, if you're living in Southern Illinois, or you live in the Metro East, but you go to work in Missouri, where there are no state protections? So that's why a national solution, that's why the Bostock decision is so important.
I'm glad you raised that, Mike, because I actually practice in the area of employment discrimination, and I would always use a little bit of a same analogy and say, what happens if you live and work in Illinois for a company and then you get transferred to a state that doesn't have those protections? You could literally, in that other state, your new boss could say, oh, I didn't know you were gay, you're fired. And you would literally have no protection, even though you were still doing the same job for the same company, but just transferred location. And so it does matter in that respect. And kind of going back to sort of where do we fight this battle, the legislative ground or the court ground? I think the answer, from what I'm hearing you say and what I agree with, is both. And even if you look at the federal law, Congress has been trying to pass what they call ENDA for years and years, which is expressly extending the employment discrimination rights to the LGBTQ community, and it hasn't yet passed. But now, we have that protection because the Supreme Court decided last week that based on sex includes those communities. Right. But the nice thing is, the court action will help to spur congressional action because they'll think, fine, they already have it. If the reverse could be true too, if the Congress had acted first, the court.
Right, and there is a piece of legislation. So it's important to remember that Bostock, and I know we all know this, but it regards employment. There are a lot, and that's critical. There are a lot of areas of life that weren't covered. So our great champions like Lambda and others are going to, they just filed a case yesterday against the healthcare rule. I saw that. So there will be continued court action to ensure equal protection in all areas of life. And on the legislative side, there is a bill in Congress right now that's passed the U.S. House called the Equality Act, which would, ensure explicit statutory comprehensive protections. It would codify Bostock. It would provide protections in public accommodations, housing, access to credit, jury service, the full range of civil rights areas of public life covered by federal civil rights laws. It's currently in the U.S. Senate, and that's another important avenue to ensuring those enduring protections.
Another thing I think is important to note about the Bostock decision is that unfortunately there was Judge Gorsuch wrote the opinion, and he did dangle out a bit of an invitation for employers or others in public accommodation to go ahead and fire people or deny them services based on their religiously held beliefs. And that would be under what they call the RFRA laws, the religious freedom laws. Do you want to talk a little bit about that and why it's important then to shore up both the legislative action, but as well as ensure that we have courts that are going to understand primacy of equal protection?
Sure. And to tackle the last point first, it's important to ensure that in Illinois we elect judges, and at the federal level that judges are confirmed to all the three levels of the federal court system, that do understand that we should not have licenses to discriminate in statutes. That protecting LGBTQ people from discrimination is a compelling government interest. That we should do that. So it's important to have judges who reflect that. And it's important to make sure that state laws then are as robust as they can be, because we do see these bills and also court decisions popping up that would carve licenses to discriminate into state laws, into federal human rights laws. We've seen a lot of these rulemakings from the Trump administration. There was a bill for several years called the First Amendment Defense Act. Incorrectly named, but that's what they call it, the First Amendment Defense Act, which would have carved licenses to discriminate on the basis of religious or moral beliefs into non-discrimination laws. And we've seen those bills even introduced here in Illinois, but because of our legislative champions, those bills never go anywhere. But it's important then to ensure that our state laws are as strong as they can be. And that's one reason why last year, Equality Illinois, we passed a bill, it's now law, to add LGBTQ folks to our jury service non-discrimination law, because we realized that was a gap in Illinois. So we did that, and we hope someday Congress follows suit with the Equality Act in that regard. But one of the trends we are seeing is attempts to use licenses to discriminate to carve out exemptions based on religious or moral belief. And we just oppose those. I know Lambda fights against those types of cases in the courts. But it's a trend we see. And it's really, it's just the arguments used for those just licenses to discriminate. It's just guise for anti-LGBTQ animus, frankly. So we push back on those. We fight those in the legislative space. And then our partners fight those in the courts as well. But that's why it's important to have, judges who don't have an anti-LGBTQ bias and who respect equal treatment, equal protection, and understand what that means, and understand that the 14th Amendment applies to LGBTQ people, as previous courts have said. That's a good question.
And one of the Masterpiece Cake case that was before the Supreme Court, with the baker who refused to bake the cake for the gay couple, the court essentially punted and said, we're not really going to substantively answer the question. We just think that the Colorado Commission was a little hostile to his religious rights, so we're going to remand it and make them be more fair. But the good news is, the cases that in the state courts are deciding under this friction between religious freedom versus anti-discrimination rights. The state courts so far seem to be saying, nope, we actually think that you don't get to use your religion to discriminate against classes of people. And I know there was a case out of Washington, I think Ingersoll was the name, and the U.S. Supreme Court said, okay, we'll revisit your decision based on our opinion in Masterpiece Cake, where we didn't really substantively decide, but we said you got to at least consider this guy's religious rights. And the Washington Supreme Court said, yeah, we looked at it again. We think we were right. You can't discriminate against gays. So, that's another really powerful example of where that intersection between the state and federal courts can really matter. And, as we saw in Obergefell, they were very swayed by what these state courts were doing and how they teed that issue up for them. So
Exactly. I do want to say something real quick.
Of course. No, I want you to.
About what Camilla said about intersectionality, which I love what she said, because, as Camilla said, Bostock wasn't the only decision last week that LGBTQ people should care about. The docket is huge. It impacts tens of thousands of LGBTQ young people. And as LGBTQ people, we need to look at judges, look at decisions, with many lenses, including reproductive justice, immigration, voting rights, environmental justice, racial justice, economic justice, because these decisions will all impact, in some way, the most vulnerable in the LGBTQ community. We think about economic rights and the rights of labor unions and people to organize in labor unions. that's important when folks are exercising their rights within the workplace, because some of the first non-discrimination protections were in labor contracts in the 70s with labor unions and employers. So, as LGBT people, we need to, have a broad intersectional view of these decisions as we evaluate judges, as we evaluate cases. How are the most vulnerable in our communities going to be affected? How are trans folks going to be affected? How are people of color going to be affected? Because LGBTQ rights are immigrant rights, are reproductive health care rights, labor rights, racial justice. And as we celebrate Pride now, we also have to remember that Stonewall was a police protest. So we're obligated to be in all these fights together for equity and justice. So I just encourage everyone that, Bostock was important, but there are many decisions that affect everyone in the LGBTQ community. We need to truly have that intersectional lens when we look at these decisions. And I think that's just important to remember in Pride Month. And with the current protests and rallies we're seeing in the United States right now.
Thank you so much, Mike. And we've talked a lot about how the courts can affect those decisions. And you mentioned, the judges themselves as well. Mm-hmm. And we've talked a lot about the Supreme Court cases, but as Carol mentioned in the beginning of the program with the slides, Supreme Court decides about 80 cases a year. Where it really happens is in those lower federal court and those state court decisions. And so I wanted to talk a little bit about the importance of diversity on the bench and ensuring that that the judiciary is not hostile to the LGBTQ community. And so Judge Horan, maybe if you could weigh in on this and tell us why it is that diversity among the judges in federal courts where they're nominated and appointed for life is so important, and just talk a little bit about the state of diversity in these last few years.
Sure. I wanted to talk about the history of diversity on the federal bench and then talk about the present state of diversity. And I finally wanted to discuss why it's important to have a bench that reflects the gender, ethnicity, religion, disability status, LGBTQ status of the population it serves. Camilla was talking about civil rights battles, and this year is 51 years since Stonewall, the riots that sparked essentially the LGBTQ civil rights movement. But it wasn't until 25 years later in 1994 that the first openly LGBTQ judge, that was Judge Deborah Batts, was appointed to the federal bench. Jimmy Carter was the first president to make diversifying the bench a priority. Prior to his administration, white men, as you would imagine, made up at least 90% of every president's judicial nominations. But when Carter took office, his nominees comprised 21% of judges. His racially and ethnically diverse nominees were 21% of his nominees, and he nominated 3 times the number of African Americans in any previous administration. Bill Clinton nominated, his nominees were almost half were from historically underrepresented groups, but Obama was the real bell ringer. In my research, I found a great article in the Washington Post from February 2016 titled, "The Number of White Dudes Becoming Federal Judges Has Plummeted Under Obama." Nearly 42% of his appointees were women and 36 were people of color, or 36%, I should say. He also appointed 10 LGBTQ federal judges. So in all, more than 60% of his nominees were from historically underrepresented groups. So contrast that to today, right? Sadly, but not surprisingly, under this president, efforts to diversify the bench have definitely regressed. His nominees are the least racially and ethnically diverse of any president over the last 30 years. I think Camilla mentioned that as well. As of last year, 78% of his appointees were male and 86% were white. And only 2 of his Article 3 appointees out of 198 are openly gay. So it's not a good situation for our community.
One of those sits here in our Northern District of Illinois and was a result of Dick Durbin flexing a very large muscle, and we have our senator to thank for that.
That's right, Judge Figueroa, and she's a friend of mine. She's great. Anyway, today more than 70% of sitting federal judges are men and 80% are white. Women, who make up 51% of the population at large, comprise only 27% of the federal judiciary. People of color make up 40% of the population, but comprise only 20% of the judiciary. And of course, people who identify as LGBTQ make up 4.5% of the population, but less than 1% of the federal judiciary. There are currently, there are currently no judges of color sitting in the Seventh Circuit Court of Appeals, even though people of color make up at least nearly 1/3 of the population of the Seventh Circuit. So I mentioned earlier that, more than ever, the average Joe is coming into contact with the court. In most cases, at least in state court, are not the high value, high profile cases that you read about in the newspaper or see on the news at night. The vast majority of the cases are the types that touch everyday people's lives, like mortgage foreclosure, debt collection, landlord tenant, small claims, domestic and criminal cases. The administrative offices of the Illinois courts collected some data, and the data showed that 70% or more litigants in civil matters are self-represented. And you can, of course, guess that that's not because they want to, miss their golden opportunity to go to law school. It's because they can't afford it. Camilla also talked, and I talked a little earlier, about a legitimacy crisis. And you can see, when you read the news or listen to the radio, that there's some deep cynicism out there about institutions generally, and the legal system specifically. And it definitely doesn't help when our president calls our justice system a joke and a laughingstock, and I put that in quotes. There was a survey that was commissioned in 2015 by the Illinois Supreme Court, and they surveyed 12,000 people from every courthouse in Illinois, asking about their experience in the court system. And the results demonstrated that about 1/3 of the respondents don't trust the courts to reach a fair result for everyone involved. And there was other research as well that shows comes to the same conclusion, and that's unfortunate.
Do you feel like, to that end, you talked a lot about the diversity of racial, gender, sexual orientation, that type of thing, that experiential diversity is also important on the courts. So for example, you have a range of former prosecutors who become judges, and trying to also then find former public defenders. You have a range of corporate lawyers. The federal bench tends to be prosecutors and corporate lawyers. Yes. And so do you find that it's important for that legitimacy aspect to sort of balance that out with people who used to represent individuals, whether in criminal law as defenders or whether in civil law as, civil rights attorneys, workers' attorneys, consumer protection attorneys, but representing the other side of protecting individual rights as well?
It's funny that you asked that question, because there was an article, I think it was, what day is today? Tuesday? I think it was late last week in this, that was put out by the Center for American Progress that I saw. I think it was quoted or cited in, it's either the anyway, it addressed that exact issue. And it said that, judges on the federal bench have a real lack of professional diversity, and that's a problem too. In my job, I do see a lot of former state's attorneys, a lot of former defense attorneys, less attorneys that came from private practice, but certainly some. And I do have a real appreciation for the variability of the experience that they bring to the bench. I was in private practice for 20 years. I never knew anything about being a prosecutor or anything about criminal law, and I get to tap into the brains of the people who do know those things. So it's really valuable for me.
Right. And so what are some of the ways that, I'll throw it back to Mike and Camilla, that we can take action? What can we do as citizens, as voters, to ensure that we do have a bench that is diverse and brings those perspectives that Judge Horan talked about to the court and to their, adjudication of cases.
I can jump. I mean, as this is an election year, one thing I think should always be in everyone's mind to vote. And when you vote, particularly if you look at the issue of courts, both are there. We have a senator on the ballot this year, Dick Durbin, and there'll be a presidential race, and of course the president nominates the federal judges. So does the candidate for president, look at their values? And that's one way of, I think, of determining what kind of justices they would appoint. I'm not going to go into any more detail on that because I think, as Judge Horan just talked about, we see the values of the incumbent when it comes to diversity and inclusion on the bench, and making sure that courts look like the communities they serve. But not just voting for U.S. Senator and President, but making sure you vote for, in Illinois, your circuit court judges, your state judges, doing the research. We talked about votefordjudges.org earlier. There's another website which I just remembered called Injustice Watch, injusticewatch.org, which has and also a judicial election guide as well. I recommend checking out justicewatch.org. But definitely, voting, but also, there are nominees to district courts and the appeals courts in the federal government being, considered by the U.S. Senate quite often. And I think one may actually be considered by the U.S. Senate today. So even if your U.S. senators, which of course Senator Duckworth, Senator Durbin, even if they're going to vote a certain way that aligns with your values and your positions, you should always reach out to them. Always call their office, because it's important, because they do keep records of who calls, pros and cons. And it's also, frankly, and I've seen this with working in the state legislature, no one calls to say you're doing a good job. So it's also important to give reinforcement from constituents to your senators as they fight these fights for judges who respect equal protection, who respect equal treatment, who respect civil rights. So always calling your U.S. senators and voting. And then the last thing I'll just say is, I think something Megan, you said earlier about I don't want to get the exact quote right. It may have been Justice Kennedy, but I don't remember that these changes are, quote, born from the grassroots. And there would have not been a Bostock without a Stonewall. So continuing agitating, continuing, the movement in the streets and the movement in state capitals and courts, continuing, the movement, because that's, a powerful mechanism for making change as well. That does make its way, as Justice Kennedy said, about, into the courts later on. So those are my 3 recommendations for what folks can do. So.
And I want to echo something that you said, and which is about the type of candidate that's been put forward by this current administration. I think, and the reason that it's so important to pay attention to who's being nominated and to call our senators and urge them to vote against nominees who have demonstrated open hostility to certain groups. One of the nominees that Trump put forward, Kyle Duncan, to the Fifth Circuit Court of Appeals, which is, right below the Supreme Court, had warned of a rapid movement toward this sort of general cultural acceptance of homosexuality and homosexual practices. He's spoken to the Alliance Defending Freedom, which is designated a hate group by the Southern Poverty Legal Law Center. Stephen Menashe, who worked in the White House as counsel, was nominated and confirmed for the Second Circuit, and he has said that the LGBTQ identities are outside and above nature, and those who support equality are attempting to peer down on the rest of creation with a godlike power to manipulate it for their own purposes. And so when you have people who are just, putting in neon lights, I don't like gay people, I don't like, I mean, why would you ever want them, adjudicating the rights of gay people, right? And the same can be said, we can point to examples for people who are hostile to voting rights and other minority groups and those rights that bringing together the intersectionality. So that I wanted to make sure that our audience is aware that we're not just making presumptions. We've seen the very words of the people that are now sitting on the bench. And the other thing I wanted to echo that you said before I flip it over to Camilla is that calling your senator matters. I've worked a lot with Durbin's office on judicial nominations, and one of the things they say is that, well, we don't really hear from people. I mean, I don't think our constituents really care that much about judicial nominations because it's not something they call about, and they do little tallies every day, who's calling on what issue. And so even calling to say thank you, or calling to say, please don't vote for this person, even if you presume that they won't, is very, very important. One of the tricks that I use is, it's not really a trick, it's just advocacy. My family are from Ohio, where they have a Republican senator. So when Corey Wilson, for example, is getting a vote this week, and he's very hostile to voting rights, LGBTQ rights, I call my family in Ohio and say, call Rob Portman, who's your Republican senator, and tell him, do not vote for this person. The senators don't hear from us, they won't care. So that is an important aspect. So Camilla, other than those items, are there some other things that we can do that you can think of that can ensure a balanced, fair judiciary, diverse as well?
Well, I'd love to encourage people to continue with watching the wonderful programming that you have scheduled at Courts Matter Illinois, and also to get more involved with not only with Courts Matter Illinois, but also Equality Illinois, Lambda Legal, and the American Constitution Society. In addition, is a wonderful way for young law students, but also lawyers to get involved, and many different organizations right now are thinking ahead in the event that there might be a different administration in January of 2021, and trying to contemplate who would be interested in serving on the federal bench if that were to occur. There are many different organizations that are making lists and trying to figure out who would be interested, who would be a good jurist. And I think it's a lot more challenging for people who are not very well represented on the bench currently, whether we are people of color or LGBT or women, to think of ourselves in that role. We tend to have a bit of an imposter syndrome and think, oh, could I do that? But this is the time to think about whether you want to do that if you are a lawyer here in Illinois, and become involved in one of these organizations and make that wish known.
I am so glad that you raised that last point, because that's another thing that the senators that I work with, their offices will tell me a lot, which is, well, people who have represented civil litigants or people in minority groups don't often think that federal judiciary is something that's open to them. So you have to encourage people to apply. So I would encourage, if you know people in that who are lawyers or or who are state court judges, for example, to go ahead and apply for the federal judiciary. The only other thing I would mention is raise awareness, right? So that's what we're trying to do today. Raise awareness, raise awareness, raise awareness. Most people don't know just how impactful these federal judicial posts are. These people are seated for life, they serve for decades, and the opinions that they write become precedent. It lives on beyond that even. And so talk to other voters, talk to your friends and family who might not understand why it matters so much who sits in the Senate, and talk to them about looking at people's record on judicial noms. And then some of the other, follow Courts Matter Illinois, our website, our Twitter and Facebook. Why Courts Matter is another one. The Alliance for Justice puts out reports on each nominee that they consider even a little bit problematic, and I think that that's great. So, there are lots of ways to easily become informed. I find that Twitter is a very good one. Following Why Courts Matter, Demand Justice, Courts Matter Illinois, they'll tell you, hey, today there's a vote on so-and-so, call your senator. So they kind of do the work for you. We have a little bit of time for questions. I know that we did have a couple of questions that came in that I wanted to pose to our panel before Carol closes us out. And so the first question that we have is, how do we best engage the average citizen in feeling that these issues are their issues and not just the purview of the LGBTQ community? And that is $1 million question. Whoever can answer it definitively, my hat's off to you. So who wants to try? Anyone? I mean, Camilla?
I think sometimes one of the things that galvanizes people the most is storytelling and is witnessing the impact firsthand of either court action or inaction. And one of the reasons why we are seeing such a powerful movement for racial justice right now is not because it's the first time we as a nation have witnessed a terrible miscarriage of justice and a tragedy and a white supremacist murder on camera. There have been more of those, multiple in fact, just in the last couple of months. But it's the accumulation of these and the fact that we are in the middle of a pandemic. And the LGBT community also has experienced a pandemic before. So in many ways, this is not new, and government inaction that has cost lives is not new. And we have come out of it as a community committed to a fight and to sticking up for each other, and to celebrating Pride every year, and a kind of a solidarity from it that I think we need to make sure includes the courts. The courts were crucial for us in vindicating the rights of people with disabilities, including HIV, on multiple different occasions. I mean, we were fortunate also to have powerful federal legislation to assist. But the courts, too, were crucial, as we talked about in the very beginning of the call, in vindicating all sorts of basic civil rights for LGBT people. And we shouldn't become complacent and think that they can't be pushed backward. The Fulton case that you described, Megan, that is coming up next term, likely to be argued in October, is a perfect example of how what we have won can be taken away. And in that case, it's religious entities that don't want to serve LGBT people, claiming that they have a religious right to disregard the law and to refuse to serve LGBT people in child welfare, even though they are doing so at taxpayer expense and at the cost of the welfare of the children in government care. So there are crucial battles coming up. I think storytelling, making sure that the faces and the families of those who are most impacted by individual cases are there for other people to see, to feel as though they can get to know them. That is crucial to creating social change and to getting people to see what the stakes are. But also relying heavily on community and activism and solidarity that we have built up as a community over years and years of battles. And we need that now more than ever. The stakes have never been higher and the courts have never been more important.
That's a great suggestion. Thank you. Another question we had is, which kind of ties into what you were talking about right now, Camilla, is will this week's decision in Bostock impact, last week's, I guess, impact some of the regulatory rollbacks by this administration?
Absolutely. So the question before the court was how to interpret the word sex in a piece of federal legislation, Title VII. Well, Title VII, as Megan mentioned, is not the only piece of federal legislation out there. There's Title IX, which protects young people in educational settings from discrimination based on sex. And there's the Affordable Care Act. There's the Fair Housing Act. And the Affordable Care Act has a specific provision that prohibits discrimination based on sex, which is particularly important for transgender people seeking health care. And you can imagine the scenarios in which this plays out. We have multiple cases on our docket where a hospital that routinely provides, say, hysterectomies says, we're not going to do it for you because of who you are. And that violates the Affordable Care Act. We've litigated that. Courts have agreed with us. The Obama administration issued a rule that said you should interpret the Affordable Care Act as prohibiting discrimination based on gender identity because that's a form of discrimination based on sex. Well, the Friday before the Bostock decision came down, the Trump administration issued a regulation saying we're not going to interpret the Affordable Care Act's protections based on sex as being inclusive of transgender people. They knew the Bostock decision was imminent, and they knew that they were likely to lose, I suspect. And they did it just hours before the decision actually came down. That was disingenuous, and it's going to hurt them, I suspect, in our litigation. We just filed a lawsuit challenging their new rule yesterday on behalf of a whole bunch of healthcare providers and individual doctors on behalf of their patients. And it's going to hurt them in litigation planned by other entities as well. So far, the courts have been extremely effective in preventing a lot of the attacks on LGBT people through Trump agencies from taking effect. We also were successful in striking down what the administration calls its conscience rule, which was a rule that it requires healthcare providers to allow their staff to refuse to treat LGBT people if they have a religious objection to doing so, or the healthcare provider will lose all of its federal funding, including Medicare and Medicaid reimbursements. And there was no emergency exception. So the administration admitted in court that its rule would require an ambulance company to allow its ambulance staff to kick a woman out on the side of the road who was bleeding out and dying as a result of an ectopic pregnancy because the ambulance driver didn't want to take the woman to the emergency room, knowing that termination of the pregnancy is the only way to treat an ectopic pregnancy that has caused internal bleeding. So the administration agreed that that was the only interpretation, but just said that that would be unlikely to happen, despite multiple cases where healthcare providers have turned away transgender people and women in need of reproductive health care based on religious objections. So that rule also was stopped by the courts and has not gone into effect. A lower court vacated it, and we're in the process of defending the lower court's ruling before an appeals court. So far we've been fairly successful.
And the Bostock definition of sex will help, right?
Yeah, absolutely.
Well, thank you so much. And I want to thank all of our panelists, you guys, not only for the amazing work that you do, but for sharing your insight with us here today. And I want to kick it back to Carol to close us out on the webinar.
Okay, and I want to thank Judge Horan, I want to thank Camilla, I want to thank Mike, and I want to thank Megan for sharing your wisdom, your insights, and for all that you do, because this was an amazing panel and with amazing information. There's one other person that deserves a big thank you, and that's Victoria, who has helped put this together from beginning to end, and we could not have done it without her. So thank you, Victoria. The second thing is I want to again thank our sponsoring organizations, and I particularly want to give thanks to Equality Illinois, Lambda Legal, and the Lesbian and Gay Bar Association, who particularly sponsored this particular webinar. And lastly, I want to thank all of you who've joined us and for your participation in this webinar. I want to remind you that our second webinar, Courts Matter to Immigration, will take place at noon on July 14th. We hope you'll join us for that one as well. Information and registration for that will be out soon. And we also hope that you will become a member of Courts Matter Illinois and be part of our family. You can go to our Facebook page and get more information about us. You can email us at courtsmatterillinois@gmail.org. And if you want, we'll put on our Facebook page some of the websites that were mentioned in this webinar. We will also post we've been taping this webinar, so we can post that there. We put together a one-page piece on Courts Matter to LGBTQ rights. That will be available also on our Facebook page. You can get that there. So please remember that courts do matter. Please vote. That's one of your superpowers. We hope you will use that. Thank you and have a great afternoon.
Thank you, Carol.
Bye-bye.